Good afternoon, everyone. My name is Chip Gibbons. I'm the Policy Director for Defending Rights in Dissent. This is another edition of Lunchtime Live. I want to thank you for once again spending your lunch with us. Today, we have two very exciting guests who are going to talk about a very interesting FOIA initiative to expose police misconduct in Washington, D.C. I am joined by Ryan Shapiro and Jeffrey Light, the co-founders of Property of the People, one of my favorite groups besides DRAD, of course. Ryan holds a PhD from the Department of Science, Technology, and Society at the Massachusetts Institute of Technology and is a former research affiliate at the Berkman Klein Center for Internet and Society at Harvard University. Ryan is a historian of national security, the policing of dissent, and government transparency. He's widely known as a leading expert on FOIA, as well as for his many, many FOIA requests that he has filed over the years. And then Jeffrey Light, if you're based in the DC area, you probably know because he has been a longtime defender of protest rights, but he is a Washington, DC based FOIA specialist attorney. Jeff is a National Lawyers Guild member who received his Juris Doctorate from Georgetown Law, as well as a Master's of Science in Bioinformatics, I think I'm saying that right, from Brandeis University. Beyond his expertise in FOIA matters, Light has extensive experience in activist defense and First Amendment law, as well as police misconduct, prisoner abuse, LGBT and civil rights laws. Jeff is widely regarded as one of the best FOIA attorneys in the country. Jeff and Ryan, thank you so much for joining us this afternoon.
Yeah, thank you for that kind introduction.
Before I get into the crux of the matter today, could you explain to people who might not be familiar with Property of the People, what it is you do and what your ethos is? Because I think it's a really cool group that people should be aware of.
Sure. Thanks, Chip, and thank you again for having us. Property of the People, we're a 501c3 nonprofit transparency organization. We believe the records of government are the property of the people, and it's time we reclaim them. Transparency is absolutely essential to a functioning democracy. If people don't know what their government is up to, then people have no idea what they're voting on. People have no idea what's happening with their tax dollars. People have no idea what's being done in their name. And so we file FOIA requests and we litigate. We sue federal agencies, especially federal intelligence agencies, FBI, CIA, NSA, and now the broader Trump administration for information about what the government does with our tax dollars and in our name. And then we get those documents, analyze them, and then provide the documents and our analysis to the public.
And for people who are not familiar with the intricacies of FOIA law, Ryan has set some important victories for us. All of my FOIA requests cite to one of his case where his Nelson Mandela case, which remains something that I imagine the FBI FOIA people still live in horror of to this day. But those of us in the FOIA requester community are eternally grateful. So what is the DC Bad Cop List? Could you explain what it is, why it exists, where it came from?
Jeff?
So the technical name for it is a Lewis list.
Yeah.
And Lewis comes from the case in DC in which the court said that certain information about witnesses needs to be turned over to criminal defendants before their trial. And that followed a line of cases from the Supreme Court. It's essential for due process in our system that criminal defendants have the evidence against them, as well as the evidence in their favor. In our system, prosecutors aren't just there to get convictions. They're also there to see that justice is done. And so they have a duty to turn over information that might actually show that a defendant was innocent. So in order to carry out that mandate, the United States Attorney's Office for DC, who does all of the local prosecution, or almost all of the local prosecutions here, created a list of police officers about whom there's information that they might need to turn over to the defendants if those police officers testify in court. And there are a variety of ways that a police officer could end up on that list. For example, they've been convicted of a crime, if they have been found by a judge to have given false testimony, if they have been disciplined by the police department's internal disciplinary board, if they're under investigation, So there are a lot of different ways that you can end up on the list, but it's not something that the prosecutors take lightly. There's a vetting process before police officers can end up on the list. So once you end up on the list, there are a lot of assurances built into the system that there is some reason for you to be there, that you've done something, not necessarily that you've done something criminal, not necessarily you've done something that should get you fired, but you've done something that bears on the credibility of your testimony in court.
And then, Ryan, you filed a FOIA request in 2016 pertaining to the Lewis list. Could you explain what you filed and what happened with it?
Sure. Well, we filed our first request in 2013 for information on the Lewis list. The U.S. Attorney's Office for D.C. took a year to get back to us, and then
only a year.
Only a year. Only a very, sadly, that's a speedy, if illegal or unlawful turnaround. The Freedom of Information Act, which is a federal statute, requires federal agencies to comply with the FOIA request within 20 or in some cases 30 working days. So a year is an egregiously long time, although sadly relatively short, for general agency performance. That said, so we filed it in 2013 and 2014. A year later, the U.S. Attorney's Office came back and said, "Oh, we don't have anything. We looked for records on the Lewis list. We don't have anything." So we submitted an appeal to the Department of Justice Office of Information Policy, which they then were like, "Oh yeah, okay, well maybe there are some things, and these people are going to sue us. So we're going to." Our request got remanded back, so it means for additional processing. And in 2014, then in 2016, they still hadn't produced anything or even done anything about the remand as far as we can tell. And so we submitted a second request for expanded related records. And then also in 2016, that's when we filed our lawsuit as a result of the agency's failure to comply with our request.
And the DC Attorney General has sought to intervene in this case. Is that my understanding is correct? Or
yeah,
no?
The police department, represented by the DC Attorney General's office, they submitted a declaration on behalf of the District of Columbia. In essence, they were supporting the prosecutor's argument that nothing in the list should be disclosed, but they went a little bit further in their reasoning and gave as examples of the reasons that the list shouldn't be disclosed. Not only that it would be embarrassing for cops for it to be known about their misconduct, but that it would hinder their opportunities for outside employment and employment after they've left the police department in DC.
And were you surprised that the Attorney General's office did this? I know DC, for people who don't know, who aren't in the DC area, DC has its first elected Attorney General, Cara Racine, who is, I think, considered rather progressive on some issues.
Well, it is fairly unusual for outside entities to get involved in a dispute in a FOIA case. It does happen sometimes. Cases are about a company's secrets, for example. But what was surprising to me is that the prosecutor's office seemed to be doing a vigorous defense. And so I'm not really sure what the police department thought they could add to that, or why they felt the need to step in and add these remarks about the importance of protecting police officers' reputations as far as getting outside employment.
And then, I guess, what's the current state of the litigation at the moment?
So we recently won on the outstanding motions, which were about whether to essentially toss the case out. And the judge found that the U.S. Attorney's Office had not explained each of the records that it had and why each record should be withheld, that they just sort of gave a blanket response of, we can't give you anything, that was not good enough. So the next thing that happens is they have to go document by document and explain why things should be withheld. I think they're going to have a really tough time justifying a lot of the individual documents because some of the things that they've withheld are transcripts from public court proceedings. It was one thing for them to just say, as a blanket matter, you can't have anything about police officers. But now when they have to actually go through and give detail, I think it's going to be a really tough thing if they actually make the argument. These things that were open to the public shouldn't be made public.
So Ryan, what are you hoping to accomplish? Why do you think this list should be in the public domain?
Well, I think there's really two sets of parallel issues here that are of tremendous importance. One, there's just the basic issue of secrecy. I mean, secrecy is a cancer on the body of democracy, and secrecy about bad cops is an especially virulent malignancy. And again, every step of the way, the U.S. Attorney's Office has fought us tooth and nail to prevent disclosure of anything having to do with the Lewis list and Lewis committee records. Again, from initially claiming that there were no records to now saying that they won't even give us like the most elementary summary of the records they're not giving us and why they won't give them to us, although we did just prevail on that point. And the secrecy isn't just an issue for our case. I mean, the residents of a city have a right to know when the supposed armed defenders of order patrolling that city have behaved so egregiously that even their own police department and the U.S. Attorney's Office knows that they can't credibly testify before a court. Secondarily, as the document that that's gotten a lot of coverage recently shows, so much of the information on the Lewis list, which is constitutionally required to be provided to defendants, is by policy not making its way to defendants. There's an epidemic of Brady violations in this country. And what the document that we obtained as part of this lawsuit shows is that, at least in DC, this is by design. If a defendant is not able to have information in the possession of the prosecution showing that the cop testifying against them is straight up not credible, I mean, this is a miscarriage of justice.
Could you explain what a Brady violation is for people who might not know that term?
I think
Sure.
that maybe is a question for me.
Okay.
So like I was saying a little bit earlier, the Brady doctrine is one that under the due process clause, the prosecutors have to turn over information to the defense that's favorable to the defense. And sometimes they don't do that. And it may be through neglect or it may be through bad faith, but for whatever reason it happens, it makes the trial unfair.
Yeah.
So what happens often is that afterwards, a defendant finds out that there was a violation of Brady. They have to go back to the court and say, my rights were affected. I should have had this information. And try and argue that their conviction should be overturned. So one of the things that we hope to accomplish with this is defendants might be able to discover that there were Brady violations in their case and that they could either prove their innocence or show that the government didn't meet its burden. So, not every instance of a Brady violation results in overturning a case, but there certainly are times where courts are convinced that the information that was withheld was so important to the case that it needs to be the case needs to be overturned.
Yeah, I know in the case of the inauguration protesters, there was a Brady violation that was found because the prosecution withheld part of a undercover video as well as the existence of other audio videos from the defense, and that the judge ruled they couldn't use that evidence in the trials, and as a result the cases were dismissed. So they can make a big difference.
Certainly it's information that's supposed to be turned over not only in advance of trial but far enough in advance of trial that the defense can make use of it, and sometimes that doesn't happen. In fact, frequently it doesn't happen. And we have a real crisis in this country of Brady violations. But, one thing I want to make clear to listeners what's at issue with these Brady violations. To say that the information needs to be turned over to the defense is not to say that it's necessarily going to be admitted at trial, right? So it may be irrelevant to the trial. It may be that it's unfairly prejudicial. It may be that it's hearsay. But even if it doesn't necessarily come in at trial, the defense has an opportunity to at least explain to the court why they think it should come in, and the adversarial system can work. If the defense doesn't know that something exists, they can't present their arguments. And so that's one of the reasons that prosecutors are directed when there's ever a doubt to disclose to the defense. Another option that the prosecutors have if the information is for some reason extremely sensitive is to submit it to the judge for the judge to make a decision without the defense being able to see it. And while that is certainly only appropriate in some extreme situations, it at least provides some way for there to be an evaluation. The government is, its duty is not contingent on the defense asking for it. It needs to come forward affirmatively with this evidence. And just so frequently in DC and throughout the country, that's not happening. And there's no real way to track how often this is happening, except when things come to light by happenstance or the diligence of a particular defendant, as happened in the inauguration case. It was one of the defendants that did all the research to discover that there was a Brady violation.
So we're nearing the end of the segment. Is there anything I missed in questioning you, or any other information about this case, or just your general work you'd like to share with our listeners or viewers, I guess, before we go?
Well, I'd just like to say this case is not is about the police officers, but it's also about the conduct of prosecutions and very systemically what's going on. We are interested in knowing what happened in a particular case, but is there a problem with the whole system of keeping a Lewis list as opposed to the way it's done in some jurisdictions in which there's just open access to the defense to get whatever they want, or in some jurisdictions where you can do a public records request and get the information directly that way. We need to evaluate whether the entire systemic approach is broken.
And thank you again for having us. And I just want to say, check us out. Everyone can check us out at propertyofthepeople.org and on Twitter at PropOTP, PROPOTP. And finally, just information about bad cops, or cops so bad that even the police department and the U.S. Attorney's Office knows that they can't credibly testify in court, is always important. However, at this moment, with the Black Lives Matter movement finally forcing white America to pay attention to the incredibly urgent and incredibly modest truth that Black lives actually matter, information about cops this egregiously bad is absolutely imperative to come out, and for the public and for criminal defendants to have access to this information. I mean, democracy and just really basic justice depends upon it.
And I would highly recommend everyone check out the Property of the People website. There is some really fascinating stuff on there, particularly the Nelson Mandela files, which perhaps some other day we can get into. Ryan, Jeff, thank you so much for joining me. Everyone watching at home, thank you for spending your lunch with us. If you're interested in more work Defending Rights in Dissent is doing, I want to say that yesterday we released the second episode of our Still Spying podcast, which is a limited engagement podcast on FBI surveillance. The first episode was on the history of the FBI's political surveillance and featured an interview with Mike German. This week's episode is about the failure to reform the FBI. In it, I tell one of my favorite stories about the time the Department of Justice tried to prosecute someone for giving FBI documents to spies, allegedly, And as a result, they had to release the documents into the trial proceedings. And those documents showed the FBI was engaged in systemic political surveillance. And it came out they were possibly wiretapping the defense, and the conviction was overturned on appeal as a result of the documents the FBI was trying to prosecute this person for releasing. We also have our board member and University of Houston Law Center law professor Emily Berman on this week's, or it's every other week, this time's episode to discuss what the current FBI guidelines are. They are shockingly lackadaisical in protecting your rights. Ryan and Jeff, thank you, and thank you to all the viewers at home.
Thank you again.